comments of states not taking part in the oral proceedings would be made accessible to the public on the first day of the oral proceedings. The written statements and written comments of states and organizations taking part in the oral proceedings would be made accessible at the end of the day on which they presented their oral statements. The written statements in question will be posted on the court's website. Let me also take this opportunity to explain the modalities that will be followed in the event of questions being put by members of the court to participants in the oral proceedings. Such questions will be asked at the close of the hearings on the afternoon of Friday, 13 December 2024, after the last delegation has completed its presentation. The written text of such questions will be transmitted to the participants by the registrar. For questions put to a specific participant or a specific group of participants, the addressees should provide their written replies by Friday, December 20, 2024 at 6 p.m. These replies will be transmitted to all other participants who may provide any written comments they may wish to make on such replies by Monday, December 30, 2024 at 6 p.m. In the case of questions, questions are put to all participants, written replies should be provided by Friday, 20 December 2024 at 6 p.m. No written comments on these replies are envisaged. Finally, I'd like to remind all those present in the Great Hall of Justice that mobile phones must be switched off during this morning's sitting so that the proceedings are not disrupted. This measure is needed due to the fact that the Dutch government will broadcast a national alert test message to all phone numbers registered in the Netherlands at 12 noon today. In this regard, it's not sufficient for mobile phones to be placed in silent mode. They must be switched off. I thank you for your cooperation. I now give the floor to the representatives of Vanuatu and the Melanesian Spearhead Group, and I invite Mr. Ralph Regenvanu to the podium. You have the floor, sir.
Mr. President, Madam Vice President, members of the Court, good morning. It is with a profound sense of urgency and responsibility that I stand before you today representing the Republic of Vanuatu and the Melanesian Spearhead Group in these historic proceedings. The outcome of these proceedings will reverberate across generations, determining the fate of nations like mine and the future of our planet. Vanuatu is a nation of islands and island peoples. Our peoples have built vibrant cultures and traditions over millennia that are intimately intertwined with our ancestral lands and seas. Yet today, we find ourselves on the front lines of a crisis we did not create. A crisis that threatens our very existence and that of so many other peoples who have come in unprecedented numbers to be heard by this court. The importance of the questions before this court cannot be overstated. At issue in this case is the legality under the entire corpus of international law of a certain conduct displayed by specific states over time, which has interfered with the climate system to a point that has already resulted in injury to Vanuatu and that threatens the survival of my people and of humanity as a whole. The General Assembly, acting by consensus, defined this conduct in clear terms. First, in question A, the General Assembly refers to, and I quote, anthropogenic emissions of greenhouse gases, end quote. As stated in the 2023 synthesis report of the Intergovernmental Panel on Climate Change, the IPCC, and I quote, human activities, principally through emissions of greenhouse gases, have unequivocally caused global warming, end quote. This is not only a statement of the global scientific consensus. It was also adopted line by line with the consensus of all states, including all those present in these proceedings. the unprecedented risks created by anthropogenic greenhouse gas emissions have been known since at least the 1960s, as detailed in our written submissions. Indeed, in an address of the 8th of February 1965, then US President Lyndon Johnson identified the problem in the clearest terms, and I quote, "This generation has altered the composition of the atmosphere on a global scale through radioactive materials and a steady increase in carbon dioxide from the burning of fossil fuels," end quote. Second, the General Assembly specifically referred in preambular paragraph 5 of Resolution 77/276 to, and I quote, "conduct of states over time in relation to activities that contribute to climate change and its adverse effects," end quote. The conduct on trial here is that of states, which have failed for over a century, despite increasingly dire warnings, to rein in the emissions from their territories. I must emphasize that since 1990, emissions have increased by over 50%, reaching an all-time high in 2023 last year. More than half of all CO2 emissions since 1750 were emitted after 1990. Whatever the time frame, there is no excuse. Third, a handful of readily identifiable states have produced the vast majority of historic and current greenhouse gas emissions. Yet other countries, including my own, are suffering the brunt of the consequences. The IPCC has recognized this climate injustice, stating, and I quote, "Vulnerable communities who have historically contributed the least to current climate change are disproportionately affected," end quote. The definition of the relevant conduct in question B thus reflects the beating heart of this request, when it asks the court to determine the legal consequences arising for states whose, and I quote, "acts and omissions have caused significant harm to the climate system and other parts of the environment," end quote. The question is therefore simple at its core. Having regard to their obligations under international law, have those states responsible for climate change acted lawfully? Vanuatu's position is clear. The conduct responsible for this crisis is unlawful under a range of international obligations, including those explicitly mentioned in Resolution 77/276. This is a legal case, and as the court will know from the written submissions, we are far from being alone in making it. Mr. President, Madam Vice President, members of the court, our delegation has just returned from the recent COP29 in Baku, where we witnessed firsthand once again the failure of the process. It is unconscionable that the COP failed to reach any agreement on cutting emissions. The current emission reduction commitments of states, even if fully respected, will see a catastrophic increase in temperature. For many people, including in Vanuatu, the prolonged and systematic failure of the COP process has cost them their well-being, their cultures, and even their lives. There is an urgent need for a collective response to climate change grounded not in political convenience, but in international law. The court, as the principal organ of the United Nations, is uniquely positioned to provide authoritative guidance regarding the entire corpus of international law. We look to the court for recognition that the conduct which has already caused immense harm to my people and so many others is unlawful, that it must cease, and that its consequences must be repaired. In closing, I choose my words carefully when I say that this may well be the most consequential case in the history of humanity. Let us not allow future generations to look back and wonder why the cause of their doom was condoned. Mr. President, Madam Vice President, members of the court, I will be followed today by 6 speakers on behalf of the Republic of Vanuatu and the Melanesian Spearhead Group. First will be Vanuatu's Attorney General, Mr. Arne Lofman, who will emphasize the need for this court to apply international law to the conduct responsible for climate change. Second will be Mr. Ilan Kiloi, who will introduce the Melanesian Spearhead Group and discuss the harms that climate change has already caused to the states and people of Melanesia. Third will be Mr. Julian Aguan, who will demonstrate that the conduct responsible for climate change has infringed the rights to self-determination of Melanesian people. Fourth, Professor Jorge Vinuales will explain that this same conduct violates the duties of due diligence, prevention of significant harm to the environment, and the protection and preservation of the marine environment. Next, Professor Margareta Wiwarinke Singh will discuss the legal consequences resulting from state conduct that breaches these and other rules of international law. And finally, Ms. Cynthia Hunuhi will share the impacts of climate change on the youth of present and future generations throughout Melanesia. I thank you for the honour of addressing you. And I now request, Mr. President, the Court to call Mr. Lofman. Thank you.
I thank Mr. Vanu. I now give the floor to Mr. Arnold Lubman. You have the floor, sir.
Mr. President, Madam Vice President, members of the Court, as the Attorney General of Vanuatu, my foremost duty is to uphold the Constitution and the rule of law. Our Constitution is a covenant with our people guaranteeing fundamental rights and freedoms and committing to the protection of our way of life for present and future generations. Our Constitution also establishes our sovereignty, which we regained in 1980 following more than a century of colonial rule. Yet I stand here before you with a heavy heart. The rights enshrined in our Constitution are being undermined. And not from within, but from the acts and omissions of certain states beyond our borders. We know what the cause of climate change is. A conduct of specific states which, as explained by Mr. Regan Vanu, Special Envoy. Vanuatu's contribution to global greenhouse gas emissions is negligible, and yet we are among those most affected by climate change. As the principal legal officer of my country, I have come before this court because domestic legal remedies are unable to address a crisis of this scope and magnitude. I have come to ask you to uphold the rule of law. Under international law, states have obligations. Obligation to act with due diligence, to prevent significant harm to the environment, to reduce the emissions and provide support to countries like mine, to protect the human rights of present and future generations, to protect and preserve marine environment, and to respect the fundamental rights of my people to self-determination in our own land. The failure by a small number of large emitting states to fulfill these obligations constitutes an internationally wrongful act, triggering legal consequences under the international law of state responsibility. Each of these states, which are identified on the basis of reliable scientific evidence in Vanuatu submission, has individually caused significant harm to the climate system and other parts of the environment. Together, they have caused catastrophic harm in the form of climate change and its adverse effects. In a system intended to uphold peace and security, self-determination, the enjoyment of fundamental rights and protection of the environment, how can the conduct that has taken humanity to the brink of catastrophe, threatening the survival of entire peoples, be lawful and without consequences? We urge the court to affirm in the clearest terms that this conduct is in breach of the obligations of states under international law, and that such breach carries legal consequences. Mr. President, Madam Vice President, members of the court, the stakes could not be higher. The survival of my people and so many others is on the line. We trust in the wisdom of this court to uphold the principles of international law. Thank you for your attention. I would now kindly ask you, Mr. President, to call upon Mr. Ilan Kiloi to take the floor. Thank you too much.
I thank Mr. Lubman. I now give the floor to Mr. Ilan Kiloi. You have the floor, sir.
Mr. President, Madam Vice President, members of the court, I have the honor to address you this morning on behalf of the Melanesian Spearhead Group, MSG, which brings together the Republic of Fiji, the independent state of Papua New Guinea, Solomon Islands, Vanuatu, and the Kanak Socialist Liberation Movement of New Caledonia, FLNKS. New Caledonia is a non-self-governing territory, and the FLNKS represents the indigenous Melanesian Kanak people. The peoples of West Papua and Torres Straits are also our Melanesian brothers and sisters. Melanesia is a tapestry of diverse people, each with their own rich cultures, languages, and traditions. But we also share, in the words of Melanesian philosopher Bernard Narakobi, a common cultural and spiritual unity, stemming from our interconnectedness with our environment. We are place persons, which means we are the places. We are the landscapes, we are the waters, and we are the soils, the stones, and we are the flora and the fauna. We are the weather, the seasons, and the spirits of our ancestral territories. Yet now, across our sea of islands, anthropogenic climate change has imperiled our people's physical survival and ripped apart the integral relationships between people and place that grounds our very existence. Simply put, climate change has unraveled the fabric of our very lives. As the court knows, we have submitted 35 testimonies from across communities in Melanesia. These testimonies contain the stories and the realities of our fathers, our mothers, and our children. Through these testimonies, our people share the sacred knowledge, their sacrifice, and their sufferings, and their grief. In return, they ask only that we bring their voices here to this great hall of justice, so that the court can understand what they are going through and how much they have lost. We respectfully ask the court to read the testimonies of our people with great care to better understand what climate change means for them, including the concrete impacts on their right to self-determination. Self-determination is at the heart of MSG mission. Each of MSG states emerged from colonial rule less than 50 years ago. Yet, climate change is now robbing our peoples from their hard-won self-determination. Melanesian peoples have been deprived of their means of subsistence, lost their territories, and suffered the collapse of their self-determined governance systems, economies, and cultures. These losses represent severe violation of their right to self-determination. Such violation is especially devastating for Kanak people and for other Melanesian peoples who are still colonized, as they compound the ongoing violations they are already enduring due to their independent political status. Non-self-governing peoples lack the ability to control their responses to climate change, or indeed even to appear before this honorable court. MSG is proud to count FLNKs amongst its membership and to bring the otherwise unheard voices of the colonized people to these important proceedings. More generally, the injustice of the climate crisis is inseparable from our shared colonial histories. The majority of the anthropogenic greenhouse gas emissions can be attributed to the conduct of a few readily identifiable states, some of which colonized and exploited the land, the resources, and the peoples of Melanesia. We have not yet recovered from the enduring violence and colonization has inflicted on us as we struggle to rebuild and assert ourselves within a system we do not create. Climate change is now depriving our peoples again of our ability to enjoy our right to self-determination in our land. Mr. President, Madam Vice President, and members of the court, the harsh reality is that many of our peoples will not survive. The conduct responsible for this existential harm cannot, and I repeat, cannot be lawful under international law. In closing, MSG joins Vanuatu in asking the court to affirm that this conduct is unlawful with ensuing legal consequences. I thank you for your courtesy and attention. Mr. President, I respectfully request that you now call Mr. Julian Angon to the podium. I thank you.
I thank Mr. Killaway. I now give the floor to Mr. Julian Agwin. You have the floor, sir.
Mr. President, Madam Vice President, members of the court. The right to self-determination is a cornerstone of the international legal order. This court has characterized self-determination as both an essential principle of contemporary international law and as a fundamental human right with a broad scope of application. Its realization is, to quote the UN Human Rights Committee, an essential condition for the effective guarantee and observance of individual human rights and for the promotion and strengthening of those rights. The right to self-determination gives rise to obligations of an erga omnes character. The right is also widely recognized as a peremptory norm of international law. Self-determination guarantees the right of all peoples to freely determine their political status and freely pursue their economic, social, and cultural development. It also encompasses their rights to maintain their territorial integrity and permanent sovereignty over their natural resources. Yet, the conduct responsible for climate change has already infringed on the right to self-determination for the many peoples of Melanesia. Over time and generations, the peoples of Melanesia have self-determined, developing sophisticated systems of governance, economies, cultures, and cosmologies, grounded in the intimate relationship between each people and their place. The well-established adverse effects of climate change have caused a total collapse of these self-determined ways of life. Melanesian peoples have already suffered forced dislocations from their traditional territories, loss of natural resources essential for both cultural and physical subsistence, breakdown of political systems and means of self-governance, and rupture of relationships to the cosmos. In short, they have lost nearly everything that has, since time immemorial, formed their very essence as peoples. In its written submissions, MSG has cataloged these horrors in great detail by way of testimonies collected from communities across Melanesia, including, but not limited to, the Uwara tribe of New Caledonia, the people of Veribari village in Papua New Guinea, the villagers of Vuni Dongaloa, Fiji, the people of Malaita province, Solomon Islands, and the people of Yakel village, Vanuatu. These testimonies unequivocally demonstrate that the conduct responsible for climate change has already caused grievous violations of the right to self-determination of peoples across this sub-region. The same is true at the level of sovereign states. In Vanuatu, for instance, unrelenting natural disasters have flung the nation into a near constant state of emergency. This Sisyphean task of responding to climate disasters has left the country simply unable to pursue its aspirations for sustainable development and has forced the government to take on substantial debt, thereby inducing dependency. These constraints, together with the degradation and destruction of the nation's natural resources, sharply curtail Vanuatu's ability to self-govern and freely determine its economic, social, and cultural development. Worse is yet to come. Rising sea levels are projected to submerge the entire territory of certain small island states, possibly within decades. This would inhibit the sovereignty of these states and thus the right of the affected peoples to fully enjoy their self-determined political status. It would also force the dispersal of peoples from their ancestral homelands, undermining their right to exist as integral peoples within their own territory, which this court stated in its most recent advisory opinion on the occupied Palestinian territory is protected by the right to self-determination. For the peoples of Melanesia, whose very existence as peoples is fused with their ancestral territories, this would be tantamount to collective death. No participant in these proceedings has disputed these facts. However, one has argued that these harms do not implicate individual state obligations. Another has contended that the right of self-determination was not designed to address climate change. These arguments miss the point. While the right to self-determination has a clear normative core, that is, the right of peoples to determine their own fate, this does not make it a static norm. In fact, the opposite is true, as preserving that core requires the application of the norm in factual situations where that right is most at risk. Indeed, the conduct at issue in this case profoundly undermines the most core aspects of the self-determination right. All states are obligated to respect the right to self-determination by refraining from any conduct that infringes on the right. The conduct at issue in this case has caused violations of the right to self-determination, violations which were foreseeable. States engaged in this conduct have thus breached their obligations to respect the right to self-determination, triggering distinct legal consequences. Mr. President, Madam Vice President, members of the court, this matter strikes at the very heart of international law. Self-determination enjoys more liberatory heft than any other single norm of international law. Yet, the reality is that the conduct of a handful of states has caused severe, systemic, and sustained violations of this right. The legal framework is robust, but still requires your affirmation to translate principles into practice. We urge this court to reaffirm the rule of law and protect the right of all peoples to self-determination. In closing, throughout these proceedings, we have taken great care to accurately describe the peoples and cultures of Melanesia even though we are aware that most aspects of those same cultures are difficult to translate into any of the languages officially recognized by this court. But we have done so because, as surely as these peoples deserve to live in the world on their own terms, so too do they deserve to be heard here. The peoples of Melanesia live exceptionally close to the earth and thus feel the vandalism visited upon it acutely. Moreover, theirs represents living, breathing, alternative imaginations, imaginations other than the one that has brought this planet to the brink of ecological collapse, thus ensuring they are able to live and thrive in their ancestral spaces is of the utmost importance, and not only for themselves, but for all of humanity. Mr. President, Madam Vice President, members of the court, thank you for your attention. Mr. President, I now respectfully call upon you to invite Professor Jorge Vinuales to the podium.
I thank Mr. Agun. I now give the floor to Professor Jorge Vinuales. You have the floor, Professor.
Mr. President, Madam Vice President, members of the court, for over 170 years, a handful of states have contributed the overwhelming majority of greenhouse gas emissions, the cause of climate change. For much of this period, international law has required states to act with due diligence to ensure that their territory is not used in a way that significantly harms others, to prevent significant harm to the environment, which includes the climate system, and to protect and preserve the marine environment. From the Alabama claims arbitration and the Trail smelter arbitration to this court's Corfu Channel case, its advisory opinion on the legality of nuclear weapons, and its subsequent decisions, most recently in the Silala case, these obligations of due diligence and prevention have been recognized as a core requirement of state conduct. Specifically, in 1996, the court confirmed, and I quote, the existence of the general obligation of states to ensure that activities within their jurisdiction and control respect the environment of other states or of areas beyond national control is now part of the corpus of international law relating to the environment. End of quote. Prevention is a cornerstone of international environmental law, and it is a general application. The International Tribunal for the Law of the Sea has recalled in its advisory opinion of May 2024 that the principle of prevention is a source of the obligation to protect and preserve the marine environment. The Inter-American Court of Human Rights, in an advisory opinion of 2017, likewise referred to the obligations of states to prevent significant environmental damage within and outside their territory as a foundation of the rights to life and integrity. The United Nations Framework Convention on Climate Change expressly confirms at paragraph 8 of its preamble the application of the prevention principle to anthropogenic emissions of greenhouse gases. The obligations of due diligence and prevention are therefore central to the present proceedings. In Resolution 77-276, the General Assembly, acting by consensus, requested the Court to have particular regard to, and I quote, the duty of due diligence, the principle of prevention of significant harm to the environment, and the duty to protect and preserve the marine environment, end of quote. Later, in formulating question B, the General Assembly used the terminology of prevention when asking what are the legal consequences of the acts and omissions of certain states which, I quote, have caused significant harm to the climate system and other parts of the environment. The Court will therefore have to clarify what were the main contributors to climate change required to do to comply with their due diligence and prevention obligations. In the palm mills case, the Court answered a similar question in the following terms, and I quote, "A state is obligated to use all the means at its disposal in order to avoid activities which take place in its territory or in any area under its jurisdiction, causing significant damage to the environment of another state." The climate system is, of course, both within and beyond the jurisdiction of affected states, and in any event, the obligation of prevention also protects the environment of areas beyond national control. In the specific context of climate change, exercising the requisite due diligence entails, according to the IPCC, rapid and deep, and in most cases, immediate greenhouse gas emission reductions in all sectors this decade. End of quote. The main source of emissions is the burning of fossil fuels, coal, oil, and gas. The International Energy Agency found in a flagship report of 2021 that reaching net zero emissions by 2050 requires that no new oil, gas, or coal projects are approved beyond those committed in 2021. Thus, when it comes to activities that significantly contribute to climate change, the required conduct was and is clear. States which have significantly contributed to climate change were and are required to achieve deep cuts of their greenhouse gas emissions, as well as of their production of fossil fuels. But they have not. For decades, what we have seen from large emitting and producing states is delay, low ambition, and in practice, concrete plans to expand the extraction and use of fossil fuels. In other words, the exact opposite of the due diligence that was and is required from them. This is not a matter of degree. The contrast between word and deed is stark. Large emitting and producing states are proactively expanding the fossil fuel production and consumption, paying lip service to their climate commitments. Vanuatu has substantiated this claim in great detail, both empirically and legally, in its written submissions. But it is useful to recall some figures. Since 1990, emissions of greenhouse gases have increased by more than 50%. The highest annual emissions ever recorded were, well, in 2023. And figures for 2024 are not yet available. According to the International Monetary Fund, the cost of fossil fuel subsidies from states reached an all-time high of $7 trillion in 2022. That is more than 23 times the figure that developing countries struggled to secure as climate finance in the recent COP29. The 2023 edition of the Production Gap Report from the UN Environment Programme, befittingly titled Facing Down or Facing Up, with interrogation marks, captures the essence of the problem. Looking at 20 large state emitters, it concludes, and I quote, while 17 of the 20 countries profiled have pledged to achieve net zero emissions, and many have launched initiatives to reduce emissions from fossil fuel production activities, most continue to promote, subsidize, support, and plan on the expansion of fossil fuel production. End of quote. That would lead, according to the UNEP, to global production levels in 2030 that are 460% 29% and 82% higher for coal, oil and gas, respectively. As I said earlier, lip service to climate commitments. Mr. President, Madam Vice President, members of the Court, such a deliberate level of subsidies and inaction attributable to specific states over a long period of time in full knowledge of the catastrophic effects for humans and the environment, at least since the 1960s, amounts to a serious violation of states' obligations to act with due diligence, prevent significant harm to the environment, and protect and preserve the marine environment. To echo the words of Attorney General Lockman, how could this deliberate conduct be consistent with international law? Major emitters and producers in the written submissions have tried to hide behind the enormity of the problem, overstating the complexity of the legal question. Yet, if an isolated incident of transboundary pollution is unlawful, it is unthinkable that the ultimate form of pollution is not. It would be like accepting the tragic irony famously noted by Raphael Lemkin, that murder is unlawful, but genocide is not. Thank you for your attention, Mr. President. I now respectfully request that you call Professor Margareta Wawrinka-Singh to the podium.
I thank Professor Wawrinka. I now give the floor to Professor Margareta Wawrinka-Singh. Professor, you have the floor.
Mr. President, Madam Vice President, members of the Court. Ubi jus, ibi remedium. Where there is a right, there is a remedy in breach. The conduct concerned in this case violates international law. The Court has been asked to articulate the legal consequences of these violations. As a majority of participants have stressed, these legal consequences are governed by the general law of state responsibility. This is confirmed by the explicit reference to legal consequences in question B of the request, and it is also clear from the use in both the English and French texts of the exact terminology of Article 42 of the International Law Commission's articles on the responsibility of states for internationally wrongful acts. Remarkably, a few participants have argued that the law of state responsibility cannot be effectively applied to climate change. But the opposite is true. Acts such as issuing licenses for fossil fuel exploration and extraction, or granting massive fossil fuel subsidies, as well as omissions such as the failure to regulate emissions or to provide finance as required under the UN Framework Convention on Climate Change and the Paris Agreement, are plainly conduct that is attributable to states under the general rule codified in Article 4 of the ILC articles. The nature of the breach is also captured in all its complexity by the rule in Article 15. This rule concerns breaches arising from a composite act, understood as, and I quote, a series of actions or omissions defined in the aggregate as wrongful, end quote. Furthermore, Article 47 confirms that when multiple states have displayed the same wrongful conduct, the responsibility of each may be invoked. the suggestion that the UN Framework Convention on Climate Change or the Paris Agreement replaces these secondary rules is, simply put, wrong. Indeed, it has already been dismissed, implicitly or explicitly, by courts around the world, including recently by the European Court of Human Rights, whose judgment in Klimasignorinen versus Switzerland expressly relies on Article 47 of the ILC articles, affirming that states can be held internationally responsible for violations stemming from their contributions to climate change. Likewise, the International Tribunal for the Law of the Sea confirmed in its advisory opinion of May 2024 that international responsibility attaches where a state breaches its climate-related obligations under the UN Convention on the Law of the Sea. Mr. President, Madam Vice President, distinguished members of the Court, this Court is called upon to affirm a similar, yet even more fundamental point, that a state which, by its acts and omissions, has caused significant harm to the climate system and other parts of the environment has thereby breached international law, and that in the ordinary way, the general law of state responsibility governs the legal consequences of that breach. The Court must not be silent on this crucial point. Silence risks implying that international law condones this conduct, that it carries no legal consequences, and that it can continue with impunity. As we all know, the legal consequences for such internationally wrongful conduct are well established. First, responsible states must cease the wrongful conduct. What does this mean? In our submission, this means not only stopping actions that fuel the fire, such as expanding and providing subsidies for fossil fuels, but also dismantling the systemic structures that drive emissions. It requires a suite of regulatory measures capable of achieving immediate and deep emission cuts, bearing in mind that the obligation of cessation is not fulfilled until a responsible state actually ceases to cause further harm. Second, as several participants have highlighted, assurances of non-repetition must be provided, including effective safeguards against false solutions that risk aggravating the harm, such as geoengineering. Third, reparations. While some participants cite difficulties establishing a causal link between wrongful conduct and specific injury, as if making reparations impossible, others rightly point out that attribution science can establish such links with great precision. More importantly, however, the Court does not need to identify a source-specific causal link to clarify the content of reparations as a legal consequence. The cardinal principle is crystal clear. Responsible states are required to make full reparation for the injury they have caused. How is this given effect in this case? In our submission, responsibility for reparations can and must be proportionate to historic contributions to the harm. As the Supreme Court of the Netherlands held in the Urgenda case, an underlying principle of Article 47 of the ILC articles is that, and I quote, partial fault also justifies partial responsibility, end quote. Examples, such as the Climate Superfund Act passed by the state of Vermont in the United States earlier this year, show that holding specific polluters accountable for climate damages is not only possible in theory, but achievable in practice. We urge the court to ensure that international law is given full force in this context. Restitution is, of course, the primary form of reparations, and there is ample scope for restitution in its ordinary understanding. For instance, ecosystem restoration is possible, at least to some extent, and responsible states must make every effort to achieve and support it. For harms that cannot be undone, monetary compensation is due. The Court's express recognition of this obligation is critical in a context where the burden of addressing losses and damages in practice remains on those injured. The financial mechanisms established in international negotiations have not changed this reality. And as a matter of law, their establishment in no way negates or replaces the obligation of compensation arising from breaches of international law. Satisfaction is required to repair spiritual, dignitary, and other aspects of the injury that cannot be cured through restitution or compensation. It should cover a wide range of measures, including acknowledgement of the harm and commemorations and tributes to the victims. The participatory rights of children and youth who occupy a proximate position to future generations merit special regard in this context. The recognition of the unlawful character of the relevant conduct is also an important form of satisfaction, consistent with the Court's practice. Fourth and finally, due to the peremptory nature of the right to self-determination and the erga omnes character of relevant obligations, the breach triggers additional obligations for all states and international organizations. Specifically, states and international organizations must not recognize the unlawful situation resulting from the breach. A concrete implication is the obligation to recognize the territory and maritime spaces of small island developing states as established under the law of the sea and their continued sovereignty and statehood despite the effects of climate change. All states and international organizations must also cooperate to bring the breach to an end. Mr. President, Madam Vice President, members of the Court, the law of state responsibility serves as international law's foundation. It ensures that no state is above the law, that violations have consequences, that rights do indeed come with remedies for victims. The magnitude of climate change and the severity of the harm already suffered underscore the urgency of applying these fundamental principles now, in these proceedings, with full force. I thank you for your careful attention. And Mr. President, I now kindly ask you to invite Mrs. Cynthia Huniui, a representative of the youth, to the floor to conclude the oral submissions on behalf of the Republic of Vanuatu and the Melanesian Group.
I thank Professor Marin Singh. I now give the floor to Ms. Cynthia Huniui. Madam, you have the floor.
Mr. President, Madam Vice President, members of the court. My name is Cynthia Rosa Barianga Haka Honiuhi. I am from Makira and South Malaita in the Solomon Islands. Within my blood flows the collective memory of my ancestors, Huta'a, who were conceived from the divine law, Warato'o, and have thrived on our islands since time immemorial. I stand before you not as an individual, but as the living embodiment of the voices of our people, past, present, and future. I also have the honor to address you as President of the Pacific Islands Students Fighting Climate Change, the youth organization that began the campaign to bring climate change before you. 5 years ago, I was one of those students who together dreamed up a plan to seek an advisory opinion from this court and brought that dream to the government of Vanuatu. 29 years ago, when this court considered the legality of the threat or use of nuclear weapons, a Masalis mother stood where I'm standing now, Legion Eknilang. She was a survivor of the US nuclear weapons testing program, which unleashed 67 nuclear weapons upon her homeland and her people. She appeared before this court to share the grave injustice inflicted upon her life, her nation, and our region, all in the spirit of contributing to the vision of a peaceful and better world. I am here to do the same. For my people, our land, Mako, is the most precious. Land is our mother, a living, timeless plane where generations past, present, and future converge, interconnected, and sustained in an unbroken cycle of life. It is upon our land that our values and principles are rooted, preserved, and transmitted across generations. Our land stretches to the distant waters where the shark Paiawa swims, rises to the heights where the eagle Huara soars, spans the rivers traversed by the crocodile Huara, and reaches into the depths of soil where the snake Moa'a burrows. For my Are people, the birthright custodians, Reoni Mai Noni, walk in sync with our clan totems, Reoni Mai, to safeguard the fundamental relationship with the divine law, Warato'o, land, Mako, and people, Noni. My people understand the continuous duty of past and present generations to protect the environment for the future generations, Kiramo. It is the adherence to this duty that enabled my people to live and thrive in harmony with our environment. This duty, Arata Inoni o Anaha, is our understanding of the legal principle of intergenerational equity. Climate change is undermining our ability to uphold this sacred contract. My people's land of Fanalei is nearing a critical point on the verge of being completely engulfed by the rising seas. Without our land, our bodies and memories are severed from the fundamental relationship that define who we are. Those who stand to lose are the future generations. Their future is uncertain, reliant upon the decision-making of a handful of large emitting states which, as my colleagues explained, are responsible for climate change. These states have not only enabled, but proactively encouraged the production and consumption of fossil fuels and continue to do so today. When the Paris Agreement was concluded, the youth of the world looked up to it as an instrument of hope. Today, the entire COP process has been hijacked by large emitters and major fossil fuel producers, turning it into a polluter-safe harbor and a trap for everyone else. No good faith understanding of the UNFCCC or the Paris Agreement can be consistent with the conduct of large emitters. By depriving the UNFCCC, the Paris Agreement, and COP process of any good faith, meaning these states have turned all three against their spirit. For my people and for the world's youth and future generation, the consequences are existential. As judges of the World Court, you possess the power to renew the power to help us course correct and renew hope in humanity's ability to address the greatest challenge of our time. And you can do this simply by applying international law to the conduct responsible for climate change. Palahenga, Chiana, and thank you.
I thank the representatives of Vanuatu and the Melanesian Spearhead Group for their presentation. Before I invite the next delegation to take the floor, the court will observe a break of 15 minutes. The hearing is suspended. Please be seated. The sitting is resumed. I now invite the next participating delegation, South Africa, to address the court, and I call His Excellency Mr. Vusimuzi Mandosela to the podium. You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the court, it is an honor to address you today on behalf of the Republic of South Africa on the obligations of states in respect of climate change. The consequences of climate change are far-reaching and are already being felt, particularly in developing countries. The best available science tells us the worst is yet to come. My own country, South Africa, is especially vulnerable to the vagaries of climate change due to its location in a region with temperature levels that are rising faster than the global average. We are already facing significant challenges of water scarcity and food insecurity, compounded by slow onset and extreme weather events. The unprecedented severe flooding and destruction of infrastructure that occurred over the past few years is now followed by the onset of a new drought cycle. This has a devastating impact on our people and the country's ecosystems, which is especially concerning as South Africa is one of the most biologically diverse countries. Domestically, South Africa is a country in which these severe climate challenges compound the most pressing triple challenges of poverty, unemployment, and inequality. South Africa's constitution guarantees the right to have the environment protected for present and future generations, and to do so in a way that promotes justifiable economic and social development. South Africa is fully committed to contributing its best efforts towards addressing the global challenge of climate change. In the context of our just transition and a commitment to a sustainable development path, we have submitted an ambitious nationally determined contribution under the Paris Agreement, which is backed by policies and legislation. Therefore, in considering the questions posed to it, the Court is invited to have due regard to the complex phenomenon of climate change and the national circumstances of states with different capacities and responsibilities, which is the context in which the international community developed the multilateral climate change legal regime. This legal regime recognizes that the historical responsibility for emissions lays at the doorstep of developed countries. Hence, the primary burden of responsibility for addressing it rests on their shoulders. Developed countries have accepted legal responsibility for reducing emissions, yet they have largely failed to honor it, and in this regard impacts adversely on the rest of the international community. According to the Intergovernmental Panel on Climate Change, whereas Africa is one of the geographical regions that is most affected by climate change, it has contributed only 3% to this historic cumulative fossil fuel emissions between 1850 and 2019, whilst developed countries have contributed 57%. Emission reductions, therefore, require clear equity considerations on which climate change law must be based. Developing countries, which bear the least responsibility for causing climate change, do not have sufficient means to deal with its adverse effects, amidst other pressing developmental and inequality challenges. It is estimated that it will cost trillions of dollars and significant technology transfer to keep within the 2 degrees temperature goal set in the Paris Agreement, let alone the 1.5-degree goal that African countries consider a necessity. It is therefore estimated that on average, African countries spend nearly 1% of their government budget on adaptation to climate change alone. This represents 10 times more governmental expenditure on adaptation than the total international support provided for adaptation. Cost multipliers include the loss and damage associated with the adverse effects of climate change and recovery efforts related thereto. The multilateral regime centered on the United Nations Framework Convention on Climate Change, the UNFCCC, is the international community's collective response to climate change. Based on the context I have briefly summarized, the Convention focuses on sustainable development and the differentiated responsibilities of states, taking into account the pressing needs and capacity constraints of developing countries. The Convention approach is that a climate change response must be conducive to sustainable development and to inclusive and equitable global decision-making processes. It is critical that any climate response must be done in a manner that is in line with the concept of a just transition. Equally, it is essential that vulnerable persons, in particular local communities, women and children, are not made to suffer further as a result of a climate response that fails to take their circumstances into account. There is a need for an all-economy, all-society response to this common concern of humankind. This response requires shifting from a high to a low-emissions economy, from incremental to transformative adaptation and climate resilience, whilst building an inclusive, employment-intensive economy. Without adequate support through funding and technology transfer, developing countries will be rendered continually vulnerable to the adverse effects of climate change and may find themselves regressing in developmental gains made thus far. With that, Mr. President, distinguished members of the Court, it is now my honour to request you to invite Ms. Bremer, Principal State Law Advisor, to address you on the applicable law, and thereafter Mr. Scholz, State Law Advisor, to address you on the legal obligations of states and their legal consequences. I thank you.
I thank His Excellency Mr. Madonsela. I now give the floor to Ms. Romy Bremer. Madam, you have the floor.
Mr. President, Madam Vice President, distinguished members of the Court, I'm honoured to address you to make South Africa's submissions regarding the applicable law on which the Court should base its advisory opinion on the questions posed to it by the General Assembly. Climate change is intrinsically linked to development and impacts on most, if not all, of the Sustainable Development Goals. The existing developmental challenges faced by developing countries, like my own, will undoubtedly be further exacerbated by climate change. The SDGs carry with them responsibilities and obligations for states at both international and national levels. And it is of the utmost importance that the Court takes this into consideration. An analysis of climate change law that does not take into account the wider sustainable development agenda may lead to conclusions that would upend carefully negotiated international and domestic consensus positions that have taken many years to develop. Climate change cannot be elevated above or separated from other sustainable development imperatives and obligations through a silo-based approach to state responsibility. Furthermore, the preamble to the Paris Agreement acknowledges that human rights should be considered when taking action to address climate change, especially when it comes to the protection of the rights of most vulnerable persons, which includes local communities, women, and children. We also recognize that international climate change policy and law have to accommodate other emerging international legal norms, such as the right to development. While South Africa fully recognizes that there are numerous legal instruments that have relevance, we submit that it would be most appropriate for the Court to apply the Convention, the Kyoto Protocol, and the Paris Agreement in answering the questions placed before it, being the most directly relevant applicable law governing the obligations of states in the context of climate change. Given that the Convention and Paris Agreement enjoy universal membership, the Court should be primarily guided by the obligations contained in these treaties. This will ensure that the Court's advisory opinion reflects the consensus of states. It is also important to note that these treaties establish compliance mechanisms that can impose corrective measures. When these measures are not adhered to, then the general rules of state responsibility are triggered. As has already been stated, it is imperative that the Court, in its consideration of this advisory opinion, bear in mind the historical responsibility for climate change, as well as the Convention's guiding principles of equity and common but differentiated responsibilities and respective capabilities in light of different national circumstances. The Convention notes in its third preambular paragraph that the largest share of historical and current global emissions of greenhouse gases has originated in developed countries. In the lead-up to the negotiations and adoption of the Convention, developing countries were firm that any climate change response would have to be done in a manner that did not hamper their economic development. This is indeed reflected in the Convention, which additionally requires that its objective, being the limitation and stabilization of greenhouse gas concentrations in the atmosphere, should be pursued in a way that enables sustainable economic development. The Convention states in specific terms that parties must be guided by the principles listed in Article 3, including the principle of sustainable development. Importantly, this was deliberately underscored in the Kyoto Protocol and the Paris Agreement by states agreeing that both must be implemented in a manner that pursues the objective of the Convention and must be guided by the principles contained therein. These principles must therefore serve as the lens through which obligations arising from the Convention, the Kyoto Protocol, and the Paris Agreement are assessed. I pause here to draw the Court's attention to the fact that both the Kyoto Protocol and the Paris Agreement, while distinct, are under the Convention. These agreements are intrinsically linked to the Convention and cannot be read in isolation. It is additionally important to underscore that the Paris Agreement did not replace the Convention or the Kyoto Protocol. There is no provision in the Paris Agreement which suggests that it supersedes either the Convention or the Kyoto Protocol. On the contrary, the Paris Agreement provides in Article 2 that it serves to enhance the implementation of the Convention and its objective. Article 3 of the Convention contains two core principles that permeate aspects of states' climate change response, namely equity and common but differentiated responsibilities and respective capabilities. Equity relates to the usage of the planet's natural resources, including its carbon space and access to opportunities linked to just transitions, and towards more sustainable modes of production and consumption. CBDR and RC comprises two elements. Firstly, the common responsibility of all states in relation to the protection of the environment, and secondly, the different circumstances of states, both in terms of their contribution to the problem, as well as their ability to prevent, reduce, or control the threat. Crucially, this principle acknowledges the specific needs of developing countries, which give rise to different obligations for different states. These differences were reflected in the use of Annexes 1 and 2 of the Convention, which contain lists of certain developed countries to which certain obligations are assigned. This approach was maintained in the Kyoto Protocol. The Paris Agreement takes a more nuanced approach in its distinction between developed and developing countries. However, it was agreed that the distinction must remain, as it is an inescapable reality. It must be stressed that developed countries had the benefit of industrializing at an early stage, which contributed extensively to climate change. Developing countries, on the other hand, have not received the economic benefits of industrialization and are thus faced with the detrimental effects of climate change and little financial capacity to respond thereto. As such, developing countries' responses to climate change must factor in their specific national capabilities. But it is also essential that developed countries assume their role in assisting developing countries through funding and technology transfer, in responding adequately to climate change to enable a truly global response to this global threat. Whilst the Convention, the Kyoto Protocol, and the Paris Agreement are all treaties that created binding rights and obligations on the part of states, the decisions taken at annual conferences of the parties to implement these rights and obligations are generally not regarded as legally binding. Notwithstanding, as the purpose of the multitude of decisions is to give practical effect to the rights and obligations of the parties set out in these treaties, the Court must also have regard for these decisions. To not do so will hinder the Court from having a holistic view and a full understanding of the matter before it. In rendering its advisory opinion, the Court must be cognizant of the already mentioned guiding principles and decisions taken at the COPs. These were formulated through extensive and careful negotiations and are therefore a true expression of the intent of states regarding their obligations in respect of climate change. Mr. President, distinguished members of the Court, it is now my honour to request that you invite Mr. Scholes to address you on the obligations of states and legal consequences. I thank you.
I thank Ms. Bremer. I now give the floor to Mr. Scholz. You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the Court, I'm honoured to address you to make South Africa submissions regarding the legal obligations of states and the legal consequences. The fact that developed countries, bear the greatest responsibility for the historic and current levels of greenhouse gas emissions translated into different and more onerous legal obligations for developed countries. The United Nations Framework Convention on Climate Change, adopted in 1992, places a clear obligation on developed countries to take the lead in addressing climate change. The Convention does not set a quantified collective goal, nor any individual quantified targets to be fulfilled by developed countries. Instead, the Convention creates various obligations of conduct. One category of obligations is applicable to all parties, taking into account their common but differentiated responsibilities and specific national and regional development priorities, objectives and circumstances. Another category is specifically applicable to developed countries and states listed in Annex 1 to the Convention that are required to take steps to reduce greenhouse gas emissions. A further category of obligations is applicable to developed countries and those states listed in Annex 2 of the Convention. They are obliged to support developing countries through the provision of finance, technology transfer and capacity building. The Kyoto Protocol, adopted in 1997, took a further step by establishing obligations of result by setting prescribed emission reduction targets for developed countries. These are targets that are contained in Annex B to the Protocol. This approach of the historical responsibility of developed countries, as well as the fact that more ambitious action is needed from them if climate change is to be mitigated at all. Importantly, neither the Convention nor the Kyoto Protocol set binding emission reduction targets for developing countries. The Paris Agreement, adopted in 2015, set 3 overarching collective goals on mitigation, on adaptation, and on the financing of climate action. Parties agreed to limit the increase in average global temperatures to well below 2 degrees and to pursue efforts to strengthen this goal towards a limit of 1.5 degrees. As for the obligation of individual states, the Paris Agreement provides that these would be self-determined. Parties must submit successive nationally determined contributions, and each NDC must be more ambitious than the previous one. All parties, including developing countries, are obliged to submit NDCs and to pursue domestic mitigation measures to achieve goals that they have determined for themselves based on specific circumstances. The Paris Agreement clearly states that the obligations of parties will be implemented to reflect equity and the principle of common but differentiated responsibilities and respective capabilities in light of different national circumstances. This qualification is an essential element which the Court must consider to ensure that equity and justice prevail. While achieving a specific target is not a legally binding obligation, there is an obligation to pursue successively ambitious mitigation measures. Such obligations must be interpreted in line with the principle of prevention, which this Court has found to be a customary rule in the context of the law concerning transboundary harm, and which has its regime in the obligation of due diligence. This Court, in the pulp mills on the River Uruguay case, found that a state is obliged to use all the means at its disposal in order to avoid activities which take place in its territory or in any area under its jurisdiction that causes significant damage to the environment of another state. The phrase, "the means at its disposal," is a crucial consideration. It requires having regard for the particular facts and circumstances that pertain to the state in question. This phrase also echoes the principle of CBDR and RC and is reflected in the fact that different legal obligations apply to different categories of states. The parties to the Paris Agreement do not have the same means at their disposal. They therefore do not have the same legal obligations in respect of climate change. Developed countries bear a greater responsibility to reduce their own greenhouse gas emissions, not only because they have historically contributed significantly more emissions, but also because they have greater resources to invest in a low-carbon future. In line with the principle of progression envisioned in the Paris Agreement, the Kyoto Protocol targets for developed countries must be the starting point for their NDCs under the Paris Agreement, not only in respect of specificity, but also in respect of ambition. Mr. President, members of the Court, mitigation of climate change is not the only issue. The Convention also recognizes that communities have to adapt to those effects of climate change that are already inevitable. Under the climate change treaties, enabling countries to deal with the increase in the intensity and frequency of extreme weather events is given the same priority as the goal of reducing emissions. Article 4 of the Convention is crafted in peremptory language and requires parties subject to CBDR and RC to design and implement programs containing measures that facilitate climate change adaptation. Furthermore, they are required to cooperate in preparing for adaptation to the impacts of climate change. The Kyoto Protocol reaffirms existing obligations of parties under the Convention, while the Paris Agreement obliges parties to engage in adaptation planning processes and the implementation of actions, and also creates a legal obligation on enhanced international support to be provided to developing countries. The importance of adaptation responses to climate change cannot be overstated. However, the success of adaptation plans is dependent on the capacity of countries to implement them. The United Nations Environment Programme has estimated that developing countries would likely have to spend hundreds of billions of US dollars annually for the next 10 years in order to cover the costs related to adaptation. The need to assist developing countries with financial resources is critical. The Convention, the Kyoto Protocol and the Paris Agreement all establish clear obligations to provide financial resources to developing countries, both for mitigation and for adaptation. The Convention expressly states that the extent to which developing countries will be able to implement their commitments under the Convention depends on the financial resources and transfer of technology provided by developed countries. Without the much-needed finance and technology transfer, developing countries were and still are restricted in what they can do to implement their commitments. Developed countries undertook to mobilize $100 billion per year by 2020 to address the needs of developing countries. Although they failed to deliver on this goal, the parties to the Convention nevertheless recognized the need for large-scale support, and this finance goal was increased recently at the 29th Conference of the Parties to $300 billion. It is an inescapable fact for developing countries to implement their NDCs under the Paris Agreement that they will require adequate financial assistance and technology transfer. If such support is not forthcoming, they cannot be held legally responsible to fully give effect to their NDCs. The legal obligations of parties to the Convention, the Kyoto Protocol and the Paris Agreement must be viewed through the lens of the Convention principles, in particular sustainable development, equity and common but differentiated responsibilities and respective capabilities. The obligations of states in respect of climate change are nuanced, and different states have different obligations. The legal consequences flowing from different obligations are therefore not uniform and require a case-by-case assessment. Having regard for each state's level of development, its particular circumstances, as well as the level of support that a state is able to provide, or the level of support that it requires. Mr. President, members of the Court, to conclude, the Convention, the Kyoto Protocol and the Paris Agreement were carefully negotiated over several decades, having due regard for a variety of factors, including the varying levels of development of countries and their varying capabilities to respond to climate change. There is no question that there are legal obligations on states to take significant and progressively more ambitious action. However, it is important that when reaching any conclusion regarding the obligations of states in respect of climate change, a proper assessment needs to be made of the responsibility of states for historic and current emissions, as well as their specific national circumstances, including their varying levels of development. The Court's advisory opinion presents a rare opportunity to take stock in a systematic way of the international law principles applicable to climate change that have developed over more than 3 decades. It is an opportunity to remind states of the legal obligations that they have agreed to. The Court's opinion can be of great benefit to the ongoing multilateral talks under the auspices of the Convention, where states have to make difficult compromises in order to ensure a future that is safe, prosperous and fair. Mr. President, Madam Vice President, members of the Court, this concludes the submissions on behalf of South Africa. I thank you very much for your attention.
I thank the representative of South Africa for their presentation. I now invite the delegation of Albania to make its oral statement, and I call upon Mr. Armand Scapi to take the floor.
Mr. President, Madam Vice President, distinguished members of the Court. It's an honor to appear before you today on behalf of the Republic of Albania. You'll hear 2 statements in Albania's name today. I will open with a general observation and then address the horizontal disparities in the impact of climate change on states and how these disparities translate into the responsibilities of states to take meaningful steps to address climate change. I will be followed by Mrs. Sherry Blair, who will address the vertical dimension, setting out how existing patterns of marginalization and inequality must inform states' duties to protect those most affected by climate change. Mr. President, members of the Court, let me start with a broad observation. This hearing takes place in the shadow of COP29 summit. As you have already heard this morning, there are already sharp debates about whether the outcome of that meeting was sufficient to address the looming threats of climate change. Albania shares the concern expressed in the joint submissions by the Vanuatu and Melanesian Spearhead Group, and I do not repeat those here. Speaking in Baku, Albania's Prime Minister, Mr. Edi Rama, expressed his and Albania's frustration with the current state of debate about climate change, commenting that, I quote, "Life goes on with its old habits and our speeches, full of good words about fighting climate change, changing nothing," end of quote. In his scripted statement, he highlighted the importance of global ambition and collective action and shared responsibility. The Court's voice, its opinion, addressed to the General Assembly and also the wider world, will be critically important and delivered at a critically important time. We urge the Court to be bold, direct, and clear in its statement of what the law requires to meaningfully address the threats we face. It is Albania's view that the law as it stands today requires states and others to take meaningful action to address climate change. We are not asked to make new law. This is neither your task nor your competence. You are, though, asked to advise both on the obligations of states under international law and on legal consequences under those obligations for states whose acts and omissions have, over time, caused significant harm. Your opinion should, therefore, in Albania's view, address the responsibility of states, including with regard to obligations to address and regulate conduct, both action and inaction, that causes or would cause significant harm to the climate system or part of the environment. You are asked, in declaring the law as it is, to bring a clarity to the law that will both allow and require states to take the action required of them and require accountability for a failure to do so. Mr. President, members of the Court, I now turn to my more substantive submissions. Climate change is a global crisis. This unprecedented level of participation by states in these proceedings underscores an undeniable truth. No state will be spared from the far-reaching impacts of climate change. This appreciation of itself demands a bold, direct and clear statement of what the law requires. But this appreciation is only part of the picture. Its effects are and will be felt unevenly, both by states and by peoples. As the World Bank has noted, it is developing and middle-income nations that are, I quote, likely to bear the greatest burden of climate change in terms of loss of life and relative effect on investment and the economy. Take Albania. We are a middle-income country at the heart of Europe. We have consistently produced some of the lowest levels of CO2 and anthropogenic greenhouse gas emissions in Europe. Yet, as the World Bank has recognized, we are one of the countries most severely affected by climate change. The Albanian coastline, a key part of our national life and driver of our tourism and economic growth, faces severe threats from rising sea levels, coastal erosion, and extreme weather events. Changes in rainfall patterns and increasing temperatures threaten the agriculture sector, a vital pillar of our economy. Albania's celebrated reliance on hydropower, approximately 90% of our electricity generation, is undermined by water scarcity caused by drought and erratic precipitation. Our progress, hard-won over decades, hangs in the balance. Climate change, threatens our economic stability, erodes our social resilience, and obstructs our path towards sustainable development. Our neighbors in the Western Balkans face similar challenges. Our region is one of the areas in Europe most heavily affected by the impact of climate change. This trend is projected to worsen, with temperature rise expected to increase to 4 degrees and potentially beyond 5 degrees by the end of this century. Despite Albania's proactive mitigation and adaptation efforts, the scale of the measures required far exceeds our available financial resources. The World Bank estimated that we require $6 billion of investment for adaptation measures alone, more than 1/4 of our GDP. The Western Balkans collectively needs $37 billion for adaptation. This financial burden and should not be borne alone by our economies. By our people, we are in need of assistance. Mr. President, we are neither shirking our responsibility nor advancing a case for development aid, pulling on the heartstrings of developed states, pleading for handouts. In our view, while all states must mitigate emissions, to enable this, the law imposes differential responsibilities on states. Greater action is required of those whose actions have contributed and will continue to contribute most acutely to climate change, and of those who can most afford to take meaningful actions to address the threats. The Special Rapporteur on Human Rights to clean, healthy and sustainable development has observed, I quote, "The main contributors to the problem have reaped immense economic benefits and thus have the greatest responsibility to solve the problem." This observation lays bare the injustice at the heart of the climate crisis and underscores the need for your advisory opinion to affirm expressly two existing and complementary sets of legal obligations. First, that developed, industrialized states, those who possess greater resources and, historically, bear disproportionate responsibility for global greenhouse gas emissions, are obligated to take material steps in significantly reducing emissions. Second, that these states are obligated to contribute financial resources to facilitate technology transfer and to build capacity to enable developing and middle-income countries to mitigate the impacts of climate change and adapt to its adverse effects. These obligations are not novel or controversial. They are at the heart of a golden thread that runs through the corpus of international law you are asked to examine. For instance, the Kyoto Protocol includes multiple provisions expressly requiring state parties to cooperate to take all practicable steps to promote, facilitate and finance the transfer of or access to technologies and know-how pertinent to climate change, in particular to developing countries. Similarly, amongst the key obligations of the Paris Agreement are the following. First, that developed state parties shall provide financial resources to assist developing state parties with respect to both mitigation and adaptation. Second, that parties shall strengthen cooperative action on technology development and transfer. Third, that support, including financial support, shall be provided to developing state parties, including for strengthening cooperative action on technology development and transfer at different stages of the technology cycle. An affirmation of this differentiation of obligations is also found in UNCLOS, which, as ITLOS clarified in its recent advisory opinion, requires state parties to provide, I quote, scientific, technical, educational, and other assistance to developing states that are particularly vulnerable to the adverse effects of climate change, end of quote. As the tribunal recognized, doing so is a means of addressing the inequitable situation of climate change. These differential obligations also find expression in the customary obligation of states to prevent transboundary harm, where developed and industrialized states have a more stringent due diligence obligation. Moreover, as recognized by numerous states, these differences in obligations are an expression of the general principles of cooperation and equity. Mr. President, members of the Court, Albania urges the Court to have this central legal truth at the center of your advisory opinion, that developed, industrialized states bear the primary responsibility to take meaningful action as required by law to address the climate change crisis to which they have and are continuing to contribute disproportionately, and that this includes real and tangible support for developing and middle-income countries that bear the brunt of the worst of its devastating impacts. This advisory opinion will be closely considered and carefully applied in many fora affecting developing and middle-income states' climate actions. In the international investment space, guidance is needed on how states' climate-related obligations should be taken into account. While Albania welcomes and supports responsible investments, climate action must not be compromised by inappropriate arbitrary decisions that have not taken proper heed of legal imperatives relating to climate change. Albania urges the Court to affirm that commercial interests should be protected proportionately, ensuring a careful and equitable balance between states' climate obligations and investors' protected interests, an imperative not yet fully realized. Mr. President, Madam Vice President, distinguished members of the Court, this concludes my submissions. May I ask Mr. President to invite Mrs. Blair to the podium. I thank you for your attention.
I thank Mr. Scapi. I now give the floor to Ms. Sherry Blair. Madam, you have the floor.
Mr. President, Madam Vice President, distinguished members of the Court, it is a privilege to appear here today before you on behalf of the Republic of Albania. The General Assembly's request expressly invites you to examine obligations under a number of bellwether international human rights instruments. These treaties and customary international law oblige states actively to protect fundamental human rights, including from adverse effects of climate change. The Court has the benefit of extensive written submissions on these various obligations. In the time available, I would like to emphasize 3 key sets of affirmative obligations imposed on states by international human rights law. First, to prevent significant harms to the climate system and parts of the environment that would foreseeably violate human rights. Second, to ensure that the measures taken in response to climate change impacts do not themselves violate human rights. And third, to provide redress for human rights violations, including those resulting from significant harms to the climate system and parts of the environment. These obligations, as set out in Albania's written submission, may operate extraterritorially within the limits of a state's jurisdiction or control, where a clear causal link exists between the alleged violation and a state's act or omission, and where this conduct directly and foreseeably impacts on an individual's human rights. Alongside the majority of states participating in these proceedings, Albania fundamentally disagrees with the suggestions that climate change should be addressed solely within the framework of instruments expressly on climate change, without regard to the rights and obligations arising under international human rights treaties and relevant and applicable customary international law. International law is not siloed. Agreements specifically addressing climate change do not, by omission, somehow exclude or override other relevant and presumptively applicable rules of international law. To reach such a conclusion would be to take a filleting knife to the holistic application of international law and set it back decades. Albania urges the court not to adopt the approach urged upon you by a minority of states that would, in their own narrow interests, wish to see this outcome. That international law, human rights law, does not stand outside the law applicable to climate change necessarily follows from, amongst other considerations, the following. First, as we've heard, the preamble of the Paris Agreement expressly recognises the interconnection between the rights and duties that it creates and states' existing human rights obligations. Second, we have more than 15 years of Human Rights Council resolutions and the joint statement on the human rights and climate change issued by 5 UN human rights treaty bodies in September 2019 that similarly affirms the relevance of human rights law and obligations in the area of climate change. These repeated statements, intended to have normative character, cannot simply be ignored. And third, national and regional courts, as well as the UN human rights treaty bodies and various soft law instruments, have all recognised that states owe obligations and international human rights law to ensure the protection of the climate system and other parts of the environment from the anthropogenic GHG emissions. Mr. President, members of the court, yours is the only international court of general competence. As the principal judicial organ of the United Nations, you are uniquely authoritative. These proceedings have presented you with an opportunity to affirm and draw together the rules of international law relevant and applicable to climate change, providing guidance on the mandating and regulation of meaningful conduct by states to address the looming crisis. Albania urges the court to reject decisively the self-serving contention that key human rights treaties need not be considered. Indeed, that legal framework is manifestly relevant to the current challenges. Mr. President, I come now to an area of law that warrants specific comment to ensure that it is not overlooked in these proceedings. That is the law relevant to gender equality and non-discrimination. UNFCCC reports have highlighted the important linkages between climate change and gender equality. The relevance of this nexus has also been recognised by the CEDAW Committee in its recommendation 37, which underscores the necessity of states integrating a gender perspective into all climate action and ensuring women's active participation in decision-making processes. But what does this mean in practice? The court needs only to look at the submissions in these proceedings and the national communications of states to the UNFCCC for compelling examples of what the gendered impact of climate change means to a lived reality of the burdens borne disproportionately by women and girls. In Albania, for example, women are more affected by climate risk owing to a higher engagement in farming, especially in livestock activities, as emphasised in the country's 4th national communications on climate change. Other examples are found in the submissions from others in these proceedings, and I take this opportunity to reference just two. First, the Melanesian Spearhead Group described how women in Yakel, a traditional Vanuatuan village, have been forced to abandon arable land destroyed by Cyclone Pam and travel almost a full day to access suitable land for cultivation. This physical toll has left many women too exhausted to even make the journey, further reducing food availability and increasing food insecurity. Second, the Cook Islands highlighted that climate change has disrupted the availability of raw materials for women's handicrafts, threatening their livelihoods and diminishing opportunities for home security, education, and participation in community decision-making. These examples underscore the importance of carefully incorporating gender perspectives in all climate change mitigation and adaptation planning and action, and the imperative of involving women and their distinctive experiences in climate change decision-making. We will not deliver equitable and effective climate policies without doing so. Climate change functions as a threat multiplier. As Vanuatu noted in its written submissions, the range of implications that flow from the adverse effects of climate change can impair the enjoyment of rights in necessarily overlapped and layered ways, amplifying the exposure to harm of women, children, Indigenous peoples, persons with disabilities, and those living in extreme poverty. These groups, already facing systemic discrimination and marginalisation, are disproportionately burdened by the various impacts of climate change. Too often, their struggles are overlooked, their contributions not valued, and their voices unheard. In affirming the law relevant to climate change, there is a need to integrate an intersectional approach, ensuring that climate action addresses the compounded vulnerabilities of these groups. This approach is consistent with statements made by the UN Special Rapporteur on Human Rights and Climate Change and with the resolutions of the UN Human Rights Council. It's also urged by the general recommendations of the relevant UN treaty bodies to those whose authoritative interpretation of treaties, in the court's own words, you should ascribe great weight. Albania calls upon the court to give this critical dimension of the climate crisis the prominence it deserves and to provide much-needed guidance on the obligations of states to address climate change and related intersecting challenges. Mr. President, members of the court, over the next 2 weeks, you will hear it said repeatedly, and rightly so, that this is a defining moment. The gravity of the issues before the court and the significance of the task before you cannot be overstated. We need your advisory opinion to set out how the law holds states to their words and commitments, and accountable for their failings. The stakes are too high, the evidence too clear, and the cost of inaction too grave to rely on voluntarism and hope alone. We also urge that your advisory opinion be guided by science. Arguments challenging or undermining the unequivocal science of climate change persist, an unfortunate hallmark of our time. Albania supports the court's close attention to the expert evidence of the IPCC and calls on the court to resist those who dispute the science or would otherwise diminish its importance to the court's task. Finally, in Albania's view, the climate crisis presents a challenge to the credibility of the international legal system itself. It is testing whether international law can rise to address humanity's most serious existential threat, or whether it will falter under the weight of unfulfilled promises and inaction, political expediency and short-termism, and the superficial attraction of simple solutions to complex problems. As has been aptly observed, international law has a strategic purpose, not merely to regulate, but to shape the society in which we live and aspire to live. It should act as a beacon, especially in the darkest days when we struggle to see through the gloom, offering stability, predictability, and the impetus for transformative change. This beacon must shine brightly now. The world requires from the Court guidance that is bold, direct, and clear with respect to what the law requires. The guidance you deliver must enable tangible, real-world application and impact, informed by the lived realities of those most affected by climate change. We heard some of their voices today, and you will have read even more. And we urge you to heed these lived experiences. By prioritising equity, equality, and non-discrimination in climate justice, you can strengthen the foundations of our international legal system, enabling everyone to contribute to protecting the rights and lives of both present and future generations. Mr. President, Madam Vice President, distinguished members of the Court, this brings my remarks and Albania's submission to a close. Thank you for your kind attention.
I thank the representatives of Albania for their presentation. I now invite the delegation of Germany to address the Court, and I call Mr. Ruckert to the podium.
Monsieur le Président, Mesdames et Messieurs les membres de la Cour, c'est pour moi un véritable honneur de m'adresser à vous au nom de mon pays, l'Allemagne. Le réchauffement et le dérèglement climatique constituent une des plus grandes menaces du XXIe siècle pour l'être humain et la biodiversité. Ils compromettent l'existence même des groupes les plus vulnérables ainsi que l'avenir des générations actuelles et futures. Il est donc impératif que la communauté internationale agisse rapidement et dans le respect du droit international. Mr. President, members of the Court, through its advisory opinion, the Court will be able to provide states with a holistic guidance on the applicable rules of international law with regard to global warming and climate change. How the international community responds to global warming and climate change is of utmost importance to Germany. Germany is a party to all relevant international agreements concerning climate protection. It was a member of the core group of states that, led by Vanuatu, drafted the resolution requesting this advisory opinion. Germany ambitiously supports all multilateral mechanisms that aim at mitigating climate change. We therefore much appreciate this opportunity to present our views on international law aspects of it. Our statement will be set in two parts. In this first part, I will focus on four issues: the distinction between legally binding obligations and voluntary political commitments, the central role of the Paris Agreement and the United Nations Framework Convention on Climate Change, the crucial role of nationally determined contributions to the global response to climate change, and aspects of customary international law. The second part of Germany's statement will then be presented by Professor Zimmermann. He will focus on the relationship of human rights law with climate change-related international law. Mr. President, distinguished members of the Court, at the outset, let me underline that the Court will greatly assist states by maintaining a clear distinction between legally binding obligations on the one hand and non-binding voluntary commitments on the other. Clarity with regard to this key distinction is crucial. Such distinction constitutes an indispensable precondition for states to be able to continue to consent to both, on the one hand, voluntary political commitments, and on the other, further legal obligations. Otherwise, the willingness of states to engage in the political processes that are paving the way forward for the necessary ambitious steps to fight climate change could be seriously endangered. In this context, it must be recalled that binding treaties can, by the same token, include provisions of non-binding character. To provide but one example, a treaty can contain permissive terms, such as may. Such terms are used to stress the freedom of parties to act in a certain way without obliging them to do so. It is this very issue that I will now turn to as far as the international legal framework regarding climate change, and notably the Paris Agreement, is concerned. Germany submits that the Paris Agreement and the UNFCCC on which it builds are the decisive treaties when it comes to determining the legal obligations of states under international law in the context of global warming and climate change. At its core, Article 2.1a Paris Agreement sets out the goal to limit the temperature increase to 1.5 degrees Celsius above pre-industrial levels, recognizing that this would significantly reduce the risks and impacts of climate change. This goal lies at the core of all obligations of the agreement, which refer explicitly to Article 2. It therefore sets a binding goal that the parties are obliged to achieve jointly. The Paris Agreement sets out also other goals for the international community that are important for achieving this common long-term mitigation goal. In particular, in Article 4, Para 1, it sets out the goal to reach global peaking of greenhouse gas emissions as soon as possible. Let me emphasize that the parties of the Paris Agreement have struck a careful balance between legally binding clauses and non-binding political commitments. When the parties construed this careful balance, they also avoided any static dichotomy between developed and developing states, while recognizing different national circumstances. That brings me to my third point, the crucial role of nationally determined contributions. Members of the Court, the Paris Agreement allows parties to set their own nationally determined contributions to the global response to climate change in the light of different national circumstances. Most importantly, according to Article 3 Paris Agreement, all parties are to undertake and communicate ambitious efforts with a view to achieving the purpose of the agreement as set out in Article 2. According to Article 3, second sentence, these joint efforts of all parties will then represent a progression over time. Article 4, Para 2, Paris Agreement, building on its Article 3, then specifies that each party shall prepare, communicate and maintain successive nationally determined contributions that it intends to achieve. All parties of the Paris Agreement are thus under a legal obligation to prepare, communicate and maintain successive NDCs. Article 4, Para 3 Paris Agreement obliges all of its parties that each such NDC reflects each party's highest possible level of ambition. This obligation to act with the highest possible level of ambition is not limited to a specific category of states. Rather, it applies to all parties of the agreement. What exactly constitutes the highest possible level of ambition will differ in the light of national circumstances. However, Article 4, Para 3 clearly states that each party's successive nationally determined contribution will represent a progression beyond the party's then current nationally determined contribution and reflect its highest possible ambition. Let me also point out the central role of scientific consensus as to adverse effects of greenhouse gas emissions, as emphasized in Article 13, Para 7, letter A of Paris Agreement. As you can see, this provision requires parties to regularly provide a national inventory report of anthropogenic emissions prepared using good practice methodologies accepted by the Intergovernmental Panel on Climate Change. The parties of the Paris Agreement accept the IPCC as a player, as it is the IPCC's reports that reflect the global consensus of the scientific community and the state of knowledge of the international community regarding climate change. The IPCC's reports are therefore of paramount importance when assessing the respective NDCs of parties. This entails that the obligations that parties of the Paris Agreement have undertaken must be viewed in light of the respective state of science. Members of the Court, this now brings me to the concept of common but differentiated responsibilities and respective capabilities, CBDR-RC, as used in and modified by the Paris Agreement. The parties to the Paris Agreement deliberately added the aspect of different national circumstance to the CBDR-RC concept. This addition constitutes a significant and particularly relevant development when compared to the UN FCCC, and it applies to all parties. This addition enables the development, as was said today already, of a nuanced spectrum of commitments, depending on the individual capabilities and circumstances of each party. At the same time, it does not allow any party to circumvent its own mitigation obligation. Instead, the agreement takes into account current economic and technological capabilities of the parties to enhance mitigation efforts. This is reflected in Article 4, Para 11, as it states that a party may at any time adjust its existing nationally determined contribution with a view to enhancing its level of ambition. The interplay between Article 4.3 and 4.11 of the Paris Agreement is future-oriented. It establishes a dynamic standard which will gradually enhance each party's climate mitigation efforts. As regards the nature of the CBDR-RC concept, Germany fully agrees with those states that have taken the position that it does not possess a normative status of its own independently of the Paris Agreement. This is evidenced and confirmed, if ever there was need, by the practice of the General Assembly, which refers to this concept exclusively in conjunction with Article 2, Para 2 of the Paris Agreement. Members of the Court, let us now move to matters of financial assistance and compensation. It has been stated by the UNFCCC's COP when it adopted the Paris Agreement that Article 8 Paris Agreement does not involve or provide a basis for any liability or compensation. This has also been recalled in decisions by the COP and by the COP serving as the meeting of the parties through the Paris Agreement on the funding arrangements for responding to loss and damage associated with the adverse effects of climate change. These decisions also explicitly provide that contributions by parties, whether developed or developing, are voluntary. Therefore, the Paris Agreement does not contain a legal obligation to provide compensation for climate change-related loss and damage. Further, the separation and distinction between Article 8 and the financial provisions in Article 9 show that the obligations regarding financial support and climate finance do not comprise loss and damage. Having said that, let me underline that Germany considers political and financial commitments to financial channels such as the Green Climate Fund, the Adaptation Fund, and funding arrangements including the Fund for Responding to Loss and Damage to be important means for assisting particularly vulnerable countries. To support such mechanisms, like Germany does, corresponds to the fact that both the Paris Agreement and the UNFCCC urge their parties to act in their best ability to combat climate change. Mr. President, the issue of cooperation leads me to my fourth and final point, namely how the Paris Agreement interacts with customary international law. Germany is, like others, of the view that the Paris Agreement is being complemented by applicable rules of customary international law. This is particularly relevant if a party decided to leave the Paris Agreement. Such a party would then continue to be bound by obligations stemming from customary international law. One of the major principles of customary international law relevant for climate change is the duty to cooperate. Germany is guided by this principle in all of its efforts to protect the environment as well as the climate system. In the context of customary international law, the question of intertemporality is central. It goes almost without saying, ever since the famous statement by Max Huber in the Island of Palmas arbitration, that a judicial fact must be appreciated in the light of the law contemporary with it. Hence, the legality of past emissions can only be assessed according to the state's legal obligations that were applicable at the time. This means that for the assessment, only those rules and standards are relevant on which uniform state practice, as well as opinio juris, can be identified at that point in time. I recall in this context that the IPCC published its first report in 1990 on how CO2 emissions impact the climate and what the risks of climate change are. With respect to anthropogenic greenhouse gas emissions, any state practice and opinio juris can conceivably only have emerged after scientific knowledge about the adverse effects of greenhouse gas emissions had become established. Mr. President, members of the Court, to summarize, a carefully balanced distinction has to be drawn between binding norms and voluntary measures, which strengthen our common climate-related mitigation efforts. Nationally determined contributions reflecting common but differentiated responsibilities and respective capabilities in the light of national circumstances allow a nuanced spectrum of commitments. The Paris Agreement and UNFCCC constitute the central legal documents outlining the obligations of state parties. They are complemented by applicable rules of customary international law. The second part of Germany's statement by Professor Zimmermann will now focus on human rights obligations of states relevant to the protection of the climate system. I kindly request that you invite him to the floor. Thank you.
I thank Ms. Ruckert. I now give the floor to Professor Zimmermann. Professor, you have the floor.
Mr. President, members of the Court, let me start by once again expressing my honor to appear before you. I will now address, as mentioned, the issue of human rights obligations of states as far as climate change is concerned. In doing so, it should be noted at the outset that the protection of human rights and the international climate protection regime constitute two parallel treaty regimes. However, human rights obligations related to climate change nevertheless do not exist in splendid isolation. As noted in the Paris Agreement, states should, quote, when taking action to address climate change, respect, promote and consider their respective obligations on human rights, end quote. The obligations states have under international climate protection law, and notably under the Paris Agreement, should therefore be informed by human rights obligations states have undertaken. Vice versa, human rights treaties ought to also be interpreted in line with the obligations states have undertaken under treaties that specifically address climate issues and that notably address climate change. This was brought out by the Human Rights Committee in its 2019 Portilla Caceres versus Paraguay decision. There, the Human Rights Committee found a violation of the right to life under Article 6 ICCPR due to the use of certain pesticides. In doing so, the Human Rights Committee stressed that Paraguay had been obliged not to allow the use of those pesticides due to the specific fact that they had already been outlawed by the Stockholm Convention on Persistent Organic Pollutants, of which treaty Paraguay was a party. The violation of this environmental treaty governing the specific activity in question was thus considered by the Human Rights Committee a crucial factor before finding a violation of the ICCPR. Mutatis mutandis, the very same considerations might then apply when it comes to climate change, human rights obligations and obligations under the Paris Agreement. And this is further confirmed by the Human Rights Committee's General Comment 36. As you see, after citing notably the Paris Agreement, the Human Rights Committee stated that, quote, obligation of states, parties under international environmental law should inform the contents of Article 6 ICCPR, end quote. And this approach is also reflected in the 2021 ILC guidelines on the protection of the atmosphere. There, the ILC confirmed that, quote, the rules of international law relating to the protection of the atmosphere and international human rights law should, to the extent possible, be identified, interpreted and applied in order to give rise to a single set of compatible obligations in line with the principles of harmonization and systemic integration, end quote. It is obvious that as far as climate change is concerned, it is the Paris Agreement that is the relevant treaty. What is more is that each and every of the state parties of all of the Universal Human Rights Treaties are simultaneously parties of the Paris Agreement. Besides, the Paris Agreement was adopted in December 2015, and thus well after the major Universal Human Rights Treaties had entered into force. It thus simply cannot be assumed that states had thereby wanted to depart from or undercut their previously incurred human rights obligations. Rather, to the contrary, states fulfilling the Paris Agreement thereby simultaneously fulfill their human rights obligations. Finding otherwise would lead to the result that states that are fully implementing their specific obligations under the Paris Agreement could nevertheless possibly be considered to violate pre-existing obligations under human rights treaties. Finding otherwise would also provide a counter-incentive for states to fulfill their obligations under the Paris Agreement since, despite doing so, they could still be considered to be in breach of international human rights law. Mr. President, Germany is not submitting that the Paris Agreement constitutes a lex specialis vis-à-vis the various human rights treaties or that the Paris Agreement has superseded the latter. Instead, what Germany is submitting is that the specific obligations arising under human rights treaties, as far as greenhouse gas emissions are concerned, must be interpreted in line with the Paris Agreement. And it is only such an approach that would also be in line with the Court's 1996 Nuclear Weapons Advisory Opinion. There, as you will recall, you similarly interpreted Article 6 ICCPR in line with relevant norms of international humanitarian law. And this now brings me to the scope of application ratione personae and ratione loci of relevant human rights treaties. Members of the Court, in the days to come, you will certainly hear arguments as to why domestic policies related to emissions, which might have an impact on the situation of a person living abroad, could by themselves establish jurisdiction of such territorial state over that person, and thereby allegedly triggering the applicability of human rights obligations vis-à-vis persons living throughout the world. Any such proposition is, however, unsuitable to address the issue of the extraterritorial applicability of human rights treaties. As the Court itself has stated, albeit in a somewhat different context, in one of its previous judgments, such proposition, quote, stretches too far almost to breaking point, the connection which must exist between the conduct of a state's organs and its international responsibility, end quote. As the European Court of Human Rights, as well as the Inter-American Court of Human Rights, have both confirmed, the existence of jurisdiction constitutes an essential threshold criterion for the applicability of human rights obligations, which must be determined prior to any assessment of the existence or non-existence of substantive human rights obligations. And it's also important to note that no particular link exists between a specific state from the territory of which certain emissions emanate and a given individual or group of individuals or even whole populations living abroad. As a matter of fact, it is the international community at large and not one or more individual states that bear responsibility for emissions causing climate change. Applying a broad concept of extraterritorial jurisdiction would entail, as the European Court of Human Rights has set out and as you see in its jurisprudence, an unlimited expansion of states' extraterritorial jurisdiction and responsibilities towards people practically anywhere in the world. Such approach would thus, in effect, turn human rights treaties into global climate change treaties. Treaties they were never meant to be. There would neither be a risk of a vacuum in the protection of human rights when rejecting an overbroad concept of extraterritorial jurisdiction, since the Paris Agreement entails, as shown, legally binding obligations for states to address the causes and consequences of climate change. On the whole, therefore, as was stressed by the Inter-American Court of Human Rights, quote, it cannot be concluded that special environmental protection regimes extend by themselves the jurisdiction of states parties of human rights treaties, end quote. Indeed, human rights treaties protect individuals from human rights violations who find themselves subject to the jurisdiction of a given state. It is thus the individuals concerned that must find themselves subject to the effective control of the state concerned. At the same time, it is irrelevant that the activities in question, i.e. the emissions, are subject to a state's jurisdiction and effective control. And in that vein, the European Court of Human Rights has held in the Duarte case that jurisdiction cannot be established merely on the basis of the argument that a state is capable of taking a decision or action impacting the applicant's situation abroad. Finally, creating by way of judicial interpretation a novel ground for extraterritorial jurisdiction, not based on the very well established notion of jurisdiction, would also overstretch the judicial function of international courts. And that brings me to the issue of human rights obligations vis-à-vis members of future, but not yet existing generations. Members of the Court, the goal of human rights treaties is to protect the actual victims of concrete human rights violations, not merely to protect abstract persons from abstract risks. Hence, possible, but not yet existing, merely eventual future acts or omissions cannot constitute violations of applicable human rights treaties. Any finding by this court therefore requires, apart from making a finding on jurisdiction, that the currently living given group of persons is currently affected in the exercise of such right. Notwithstanding, in order to maintain their compliance with international human rights law, states must continuously evaluate and adapt their mitigation and adaptation efforts in light of changing circumstances. This is required in particular to prevent the infringement on human rights of a jus cogens character and notably the right to life as well as the right of peoples of self-determination. Let me now move on to the issue of an individual right to a clean, healthy and sustainable environment. And let me start by stating the obvious. namely that an individual self-standing right to a clean, healthy and sustainable environment does not yet form part and parcel of current customary international law. The right to a healthy environment has been recognized politically by a General Assembly resolution in 2022, and I note in passing that Germany was an active supporter of this very resolution. The said 2020 General Assembly resolution on the right to a clean, healthy and sustainable development recognizes that this right, quote, is related to other rights and existing international law, end quote. Put otherwise, such right was perceived in this legally non-binding instrument as constituting a specific manifestation of other previously established human rights. The right was understood as deriving from and inherent in already existing international human rights obligations. What is more, and as you can also see, the resolution recognizes what I already had alluded to earlier, namely the need to interpret environment-related human rights obligations in line with general international environmental law. It affirmed, as you see, quote, that the promotion of the human right to a clean, healthy and sustainable environment requires the full implementation of multilateral environmental agreements, end quote. Members of the Court, as the Human Rights Committee has stated in its General Comment 36, quote, environmental degradation, climate change and unsustainable development constitute some of the most pressing and serious threats to the right of life, end quote. The Human Rights Committee has so far, however, not yet found any violation of Article 6 of the ICCPR to have been caused by climate change. It was of the view that without robust national and international efforts, the effects of climate change may in the future expose individuals to a violation of their rights under Article 6 or 7 of the ICCPR or of other human rights treaties. There exists a need, however, to carefully assess any such possible future breaches of protected human rights individually and on a case-by-case basis, and provided anyhow that the persons concerned are indeed subject to the jurisdiction of the state party in question. Members of the Court, when adopting its 2021 guidelines on the protection of the atmosphere, the ILC underlined that, quote, special consideration should be given to persons and groups particularly vulnerable to atmospheric pollution, end quote. Such groups are exposed to an increased risk of being particularly affected by the consequences of climate change, given that they are less able and often lack the necessary means and opportunities to protect themselves adequately against the hazards resulting from climate change. Subject to the issue of whether a certain person finds him or herself subject to the jurisdiction of a given state, of a treaty protecting women, children or people with disabilities, states parties of such treaties must take appropriate steps to specifically safeguard and to protect the rights of such groups. The same considerations apply mutatis mutandis as far as the rights of minorities and indigenous populations are concerned. Notably, indigenous peoples, given the habitats they are living in and depend on, rely particularly on a healthy environment. Accordingly, their rights under Article 27 may be affected if and to the extent their traditional activities are endangered by environmental degradation. Members of the Court, that brings me to the end of Germany's presentation. This advisory opinion might indeed be one of, if not the most consequential opinion the Court has ever been requested to render. Germany trusts that the Court will provide the international community with its legal guidance based on international law as it has developed over time and taken international law as a whole. Thank you very much for your kind attention.
I thank the representative of Germany for their presentation. This concludes this morning's sitting. The oral proceedings will resume this afternoon at 3 p.m. in order here Antigua and Barbuda, Saudi Arabia, Australia, the Bahamas, Bangladesh and Barbados on the question of submitting to the court. The sitting is closed.